Hello, my name is Michelle Amico, and I'm a District Court Judge in the 18th Judicial District.
Hello, my name is Mark Randall, and I'm a County Court Judge in Jefferson County.
Hello, my name is Dave Furman. I'm a judge on the Court of Appeals.
Imagine if you were reading a transcript of your own hearing. Could you identify the legal authority you are using? Could you identify the elements or factors that you were deciding? Could you identify the standard of review that you were using? Could you understand the basis for your finding or ruling? We're here today to talk with you about making findings and rulings during motions, hearings, and trials, including during bench conferences. We will suggest what makes good findings and rulings and offer some practical tips that we think will help you. We start with some general observations about making findings and rulings.
Making proper and adequate findings and rulings is one of the most important tasks of a trial judge. Statutes, rules, and case law may require you to make findings, and putting findings on the record gives the appellate court and the parties a clear understanding of the reasons for your decision.
Findings and conclusions should be sufficiently specific to indicate on appeal the basis for your decision. Trial courts have a unique opportunity that appellate courts do not have. You determine the credibility of the witnesses and the weight to be afforded the evidence in court. In these situations, appellate courts will give deference to your findings. That means your findings will be upheld if they are supported by evidence in the record. But if the necessary findings of fact on key contested issues are lacking, the appellate court will usually vacate the judgment and remand for additional findings.
Factual findings address the who, when, where, how, or why of a case. For example, in suppression hearings, witnesses may testify about identifications of a defendant in show-ups or lineups. You will likely hear testimony from a police officer or detective. It is important that you make credibility findings about these witnesses. Is there a video or audio of an interview of a victim or the defendant? Did you look at it or listen to it? If so, say so. If not, say why.
Discretion in fact-finding, when the witnesses disagree over an important fact, means you have the freedom to choose to believe one witness rather than another. When that happens, when you find one witness more credible than the other, state on the record and explain why. It is helpful to use the word because. Explain what facts are undisputed. It is also helpful to state on the record if the prosecution and defense agree on a particular issue. If you are making alternative rulings, say so.
The importance of stating on the record whether facts are undisputed, whether the parties agree on a particular issue, and why you ruled one way or the other and believed one witness over another is very important. It helps the Court of Appeals to decide whether and how we will review a contention of error. For example, we will not review an issue that a party has invited or injected into the case. We may not review a contention of error that a party has not preserved. And we will review for abuse of discretion pure factual issues, only to determine whether the trial court's decision is manifestly arbitrary, unreasonable, or unfair.
The first thing you should remember as a district court judge in making a good record is that you are not the most important person in the courtroom. Your court reporter is. The court reporter has the hardest job because he or she preserves the record that is made. So you need to make sure you do all you can to help your court reporter create a clear and concise record. It is good practice to make sure that everyone in the courtroom, from the attorneys to witnesses to prospective jurors, knows what the court reporter is doing and how hard his or her job really is. I routinely ask everyone at the commencement of motions or trial to make sure they talk slowly and clearly, and I remind them that head nods and nonverbal responses are really hard to catch. I also remind everyone how hard it is for the court reporter to get everything down when people are talking over one another. Don't be afraid to slow down attorneys if they're going too fast, or to ask prospective jurors to repeat an answer if they nod their head. Also, tell witnesses when swearing them in to speak clearly into the microphone. Your goal is to give your court reporter the best opportunity to get everything down accurately. This benefits you as the judge so that you can manage the proceedings and rule on objections. This helps make a good record for appeal. And most importantly, during trial, it benefits the jurors who are trying to hear questions asked and responses given by witnesses. When conducting bench conferences during motions or trial, make sure parties speak clearly into the microphone. You can do a quick check with your court reporter before you start to ensure he or she can hear what is being said. Attorneys tend to get very animated once they're up at the bench. Make sure you ask them to slow down and don't allow them to speak over one another. Just as a court reporter cannot capture nonverbal responses, a reviewing court cannot see what you are seeing as the trial court judge. They are reading a cold record off paper. So, if something is taking place during the proceeding that is not spoken, make a record of it. Here is an example. A witness is asked during trial how far away the robber was from her. Her answer is, "I'm not sure, about this far," and she's holding her hands up demonstrating a distance. You can either ask the attorney to supplement the record by placing on the record what is taking place, or you can do it yourself. The record will reflect the witness is holding her hands up and about 2 feet apart. If you make the record yourself, ask each side if they concur with the court's record. Likewise, where demeanor is important to a ruling you are making, make a record of it. A good example of this is during jury selection. You are granting a challenge for cause. Part of your basis is the juror's responses to questions, but part of it is because she's been very emotional and her eyes have welled with tears while she is answering. A reviewing court cannot see that, so make a record of your observations about demeanor and actions when they support your ruling. Motions and trials generally almost always include exhibits. It is your responsibility to make sure that each side marks their exhibits and there's a clear record about which exhibits you admit into the record and which you do not. Attorneys will often use a recorded interview to impeach a witness and then use only a few minutes of that interview and fail to make any record of which portion of the tape was played and also fail to do anything to include it in the record. So, if, for example, there was an objection about using this interview to impeach a witness, a reviewing court needs not only the exhibit itself, but also to know which portion was used. So ask the attorney to make a record of what was played, and then also make sure they mark the exhibit and you retain it in the record. This brings me to a point about exhibits in general. As I stated, you need to keep track of all of them, not just what was admitted into the record, but also rejected ones. And this includes demonstrative exhibits. A good practice is to ask the parties to give you an exhibit list prior to motions if that's necessary, or trial. Then keep track yourself. The parties are usually keeping track, and so is your court reporter. At the end of the trial, you can compare lists and make sure everyone has the right exhibits. Make sure your record has every item shown to the jury. If, for example, the people used a styrofoam head with the corner to show trajectory of a bullet as a demonstrative exhibit, so it was not formally admitted, and defense objected to this demonstration, then require the people to take a photograph of the exhibit and mark it for the record. Those of you who do jury trials, you know that time is of the essence, and you don't have the kind of time a reviewing court has to analyze your rulings. You have a witness on the stand, attorneys in front of you asking questions, and a jury whose time is of the utmost importance. You can't get off the bench each time there's an objection to research your ruling. You need to rule and move on. But at the same time, the reviewing court may need to know why you ruled the way you did. Here are some suggestions. State a basis quickly. For example, defense might say objection, hearsay. You might say overruled, 8033, or excited utterance, or even just falls within a hearsay exception. Or you can just rule and state sustained or overruled. Then, when the jury's outside of the courtroom at a break, you can make a further record, a more detailed record as to why you ruled that particular way. Here is the biggest piece of advice I can provide as a trial court judge about making a good record in motions or in trial. Be familiar with appellate standards of review, because this will help you with your ruling. When ruling on motions issues, state your findings of fact, your conclusions of law, and cite authority you are relying upon. The same applies during trial. You need to say, I find because. Because should become your favorite word. Type it on a piece of paper and put it on your bench if you need to. Tell the reviewing court what you found and why. Your ruling has a greater chance of being upheld on appeal if the reviewing court knows why you did what you did.
From a county court perspective, we don't have the benefit of court reporters. A tape recorder cannot interrupt if it doesn't hear something or understand something. So if people do talk over each other or are too far from a microphone to be recorded or something like that, you're the one as the judge that has to monitor this to make sure the record is clear. To be sure, the lawyers have responsible here too, but ultimately the record is yours. Frankly, at times I try to visualize how the record is going to look on a cold piece of paper, and I try to make things as clear as possible. In motions hearings, county court lawyers, well, they try hard and they often do a good job, but many are lacking in experience and tend to be overworked. The motions from the defense tend to be largely boilerplate, and the responses from the prosecution tend to be, well, largely non-existent. So making the record as to findings and the correct ruling, and sometimes even identifying the correct issue, falls on the judge. As a county court judge, you are doing a lot of motions hearings, and you can get rushed. But even if the attorneys are not thorough, you need to be. Slow down, state your findings, remember the word because, and make your rulings. As for bench conferences, recording them in county court can be very difficult. Make sure you spend time with your recording system in your courtroom to understand how it works and if it is recording whispered conferences at the bench, without amplifying those conversations through the microphone to the jury. You can tell the jury to talk among themselves or talk about the Broncos or the weather while you're at the bench, but distracting the jury does not ensure that the bench conference is actually being recorded. Because of the difficulty in getting complete transcripts, some attorneys will demand contemporaneous recordings, which we cannot assure. So then there are basically two options. One, no bench conferences at all. Many things may have to happen in open court in front of the jury. On occasion, the entire jury would be removed, which means during voir dire, the entire veneer stands in the hall. Well, this can cause delays in keeping the case moving, a case that you're trying to keep moving, and the jury can become very frustrated with what they perceive as inefficiency by the court. Or two, you can have bench conferences for most issues and try to record them, but then at the next break, put on the record what was discussed and allow each side to supplement the record. Some larger or more contested issues will still require removing the jury. There are many advantages to this procedure, but as a practice tip, discuss this procedure before the trial to see if both sides agree to it.
To summarize, first, when you're required to make findings based on a particular case or statute, expressly apply the test by first citing the legal authority. Second, put on the record that you've considered all of the relevant factors and circumstances and the credibility of the witnesses. Third, make express findings as to all of the relevant factors of the test. Explain why you are or are not persuaded that those facts exist or lead to a particular conclusion. Fourth, that means your findings should address all of the elements essential to the questions before the court, be sufficiently detailed so that an appellate court can determine how you arrived at your decision and whether the decision was supported by competent evidence. In this regard, it's best if your findings follow the same order as a statute, rule, or case you're using. Fifth, findings may be written or oral. If findings are made orally from the bench, make sure they're transcribed for inclusion in the record. As Michelle and Mark said, this includes records of conferences with counsel on jury instructions. Finally, include any documents, exhibits, or videos on which you based your findings.
Thank you for your time. And remember, if you need any help, always reach out. We're all here willing to help you. Good luck.